Hi, everyone, and welcome to Launch Network. This is Carmen Danisco, your co-host for today's 7th edition of the UIA Workshop Series. We're getting some great feedback, getting some great guests, some awesome questions. We got a lot of cool stuff going, and we got some cool future dates. And let me bring on my co-host, Mr. Warren Tuttle, talk a little bit about it. Warren, what's going on?
Hey, Carmine, it's great to see you as always. And we apologize to all of our loyal viewers. We've had a great following so far. Really apologize for last week. It was a technical glitch. Carmine and I have done 100 of these shows and never, right? Carmine never had a problem.
Yeah, weird.
So, the longer it went, the more freaked out we got. But let's face it, in the scheme of things, nobody was hurt. And we're able to move it back a week to today. So we hope everybody was able to rejoin us today. And we're going to pick it up today with the same program we would have run last week. And we'll continue our effort. We'll have 3 more weeks after this. Next week, June 11th, at the same time, we'll be on Inventor Coaching. We have 3 terrific guests there. But we got a great show today, Carmen.
Yeah, I know. That's really cool. So real quick, before you bring on, we got some great guests. Before you bring on, what's the next shows that are coming up so people can tune in for the next shows?
Yeah, so the next week, but anybody can go to the UIAUSA.org, UIAUSA.org website. We have at the top of the page the whole series. Next week is on Inventor Coaching for sure. We have David Fedua on, we have Jim DeBetta on, and we have Brian Freed. So that'll be 3 great individual inventor coaches. And then we have a session on Kickstarter and Indiegogo with Roy Morjan that will be terrific.
Yeah.
We have 1 more. So they will now run through the end of June. And so just go on the UIA website and you'll see and log in. And plus we'll be announcing them on social media, during the week. So we've got a couple more programs, and this show has been really, really well received. We had, I think, 185 folks the last session we've been building. We started with about 120, 125 live. And now I noticed on our website, again, if you go to the UIA website, UIAUSA.org, you can see our whole library of these shows, and you can go in and see the old ones and click on them. We've had a lot of views. Some of them had 400 or 500 views on them already. So yeah, so it's really, really good stuff. Very excited about it. And I promise you, folks, we're going to continue this in the fall. We'll have a whole segments every week or other week from September through December, and a lot of educational. We'll also tie it in a lot of the inventor clubs. So we think we've hit our stride here.
Yeah, it's great. It's really good. And anyone that's listening in that is live on the YouTube channel, please subscribe to this page. Subscribe to the page so we know you're there, and then it's easier for you to ask questions and do follow-ups. So awesome, man. Warren, let's get the show on the road. Let's hit it, man.
Yeah, so we have 2 phenomenal guests today. Both are UIA board members, United Inventors Association board members, give very generously and graciously of their time and money to the organization. We have Andrea Evans from the Baltimore area and the DC or Washington, DC area. And we have Jim Patterson from Minneapolis, Minnesota. And so welcome, guys. And what I'd love to do is start with each of you individually, and start with you, Andrea, to maybe give us a couple minutes about your business model and platform and what you do for the UIA. And then we'll start with questions after that. So welcome.
Thank you. And thank you for inviting me to be here today. I'm so excited to be here. As Warren said, my name is Andrea Evans, and I own the law firm of Andrea Evans, a full service intellectual property law firm. I represent a range of clients ranging from individuals to Fortune 100 clients with patent, trademark, and copyright legal matters. Before that, I worked at the U.S. Patent and Trademark Office for 5 years, 3 as a patent examiner and 2 as a trademark examining attorney. And I'm very proud to have had my firm for 13 years, and I'm a proud board member of the UIA. And in my role as a board member of the UIA, I participate in amazing events like this, but also share resources as well as help to put amazing events together at the USPTO, and just to ensure that all inventors have equal access to valuable information and resources like you're presenting today. So thank you again for this opportunity.
Hey, thanks, Andrea. And yeah, Andrea has a great background and history with the U.S. Patent Office, and she was the master of ceremonies for our event last August in association with InventionCon when we brought in all the Inventor Club leaders. So really appreciate that in a big way. Thank you. And let me introduce Jim Patterson as well, a longtime friend, and also I would say the chairman of the National Pro Bono Patent Commission. And Jim, say hi from Minneapolis, and maybe you could do the same thing as Andrea. Introduce yourself for everybody.
Sure, absolutely. Thanks, Warren, and hello from Minneapolis. We've been in the news a bit the last week. I can tell you that from my perch on the 48th floor of the IDS, all is quiet, and we hope that it will stay that way. Messages will be heard and things will take place, and maybe we can regain our good name in Minneapolis. But Andrea went backwards from the present to the past. I'll go from my past to the present. I started out my career in the United States Navy driving ships, actually. Was a young man on a destroyer homeported in San Diego and saw the world. I did see the world. I left the Navy, active duty, retired from the reserves. But when I left active duty, I went to law school, which I enjoyed immensely. I graduated, went to work in a small patent firm, got my chops there, and then worked for Dorsey and Whitney, whose building I can look right out the window and see here. Spent 10 years there at a large multi-practice international law firm, and then started the law firm of Patterson Tinty almost 29 years ago now. Like Andre, we do a full service, which means we do litigation, patent prosecution, agreements, the whole range of intellectual property. And as Warren, you mentioned, I'm very proud of my law firm in that they willingly asked me to take the time to donate back, and as the chair of the Pro Bono Advisory Council. So in terms of working with independent inventors, it's been a part of our business model, and now it's a part of our paying back as well. So
that's great, Jim, and you give so much. And so I'm going to start with you, Jim, and then we'll come back to Andrea. You know, this show is being watched by independent inventors. So I know a portion of your practice is dedicated to bigger companies, I understand, but you do a lot of stuff with independent inventors. So if I could maybe focus in on the patent side, the utility patent side.
Sure.
And then we'll get to Andrea and we'll talk about that a little bit more, maybe copyrights, but just the utility patent side. You know, how often do you work with independent inventors? Is it a big part of your practice? And when they come to you, you know, how do you get started? And what are the first steps that an independent inventor should make when they reach out to someone like you?
The short answer to your first question is yes, we absolutely work with independent inventors. And we do also work with large corporations. But it seems to me it's part of the calling as an attorney. You have to work with people across the board. You're here to give, not to take. So independent inventors are part of our practice. Pro bono is part of our practice. And in terms of the business model, it's just a good way to give back, and it's extremely satisfying when you have that independent inventor who does have a good product and then is able to commercialize it. So in general, answer is yes, we work with independent inventors, and we work with them all the way from the initial idea to getting their product out and sold.
But how do they reach out to you, Jim? Like, do they find you in the yellow pages? Oh, that's an old statement. Or do you read them through organizations? Or, I mean, I would think that especially up in the, what are you, the 47th floor or something like that? It must be a little intimidating. How does an independent inventor who's thinking about looking into patents get started? You know, how do they make a call, they email, they go online? You know, just the specifics maybe for a minute.
Yeah, how to find an attorney? Well, there's a great cartoon that goes back a number of years, and it's BC, right? If you remember the cartoon BC.
Sure.
And the first frame is a purported inventor coming to be counseled, and he says, "What do I need to get a patent? And what do I need to get a patent?" And the advice given was, "Well, you need an invention." So I do take calls from independent inventors, and how do they get our name? Yes, we used to advertise in the old pages. You have that. And how would an independent inventor listening find an attorney that's willing to work with them and someone they can trust? And I'd start out by going to, there's a network of clubs throughout the country, and Warren, you can speak to that better than I can. The best way, how do you find a doctor? You ask your neighbors, who's good? Who have you been to? Who's got a good reputation in town? So if you go to an inventors club, you say, who have you worked with? Who are the lawyers that are willing to work with individuals? Another way to, well, when I first came to town and looked for a doctor, I met a doctor. I said, who do you recommend, right? So if you know some lawyers in town and you know whether or not they're in the intellectual property business, they are going to know people that have good reputations and poor reputations.
Get you started, great. So Andrea, I'll turn it over to you with a similar question, but just I sense that you have a national following, but tell, as you answer the question also how people come to you, do you work with people nationally, internationally? Do you get a lot of your practice locally, or just where do people find you?
The beauty of intellectual property is that it's federal. So we're able to represent clients all over the world with US intellectual property issues. And I am very proud that I have a global list of clients that find me, as Jim said, by word of mouth. And what I find is that like-minded people surround themselves around like-minded people. So that's the beauty of an organization like the UIA and all these inventor clubs. They sort of hang around each other and say, hey, how did you do it? And so a lot of my practice is word of mouth. A lot of it is that I do a lot of social media and getting the message out there about the importance of intellectual property, what to do once you have an idea. Is that idea enough that you can describe it to make it a real invention? And then to answer your question, the most important thing you can do as soon as you think you have the next best idea is research. And so you can do free research just using tools like Google. But of course, you want to consult with an expert patent attorney to interpret those results. That's the main thing, because the worst thing you can do is think that you have the next best idea and invest thousands of dollars in a patent application or invest in filing a patent application only to learn that it's out there. And so one of the biggest myths, Warren, is that people assume because they haven't seen the invention on the store shelves that they have something that's patentable. And as you know, often people have patents and it may take a while for it to get to market. So as soon as you think that you have the next best idea and you're able to talk about that idea in a way that someone can make or actually use that invention, you're ready to sit down with an attorney and schedule a consultation.
So let me just get a quick advertisement in for, so those who are watching today that are looking for where clubs are in your local areas around the country, you can go on the UIA website, uiausa.org, and you will see over on the right side a listing, pull it down, of clubs all around the country. And I think what Andrea and Jim are both saying, join those clubs or at least go to the meetings and network there and all, and find out more about it. So let's talk, Andrea, a little bit more, because you're so personable, and I bet it'd be fun to come and see you, because when someone calls you, do you do like a phone call? I guess today it's all phone, right? A little consultation. I mean, at some point they got to be nervous, right? And how do what do you talk about in the beginning before the bill starts, running and all that? And,
Well, good question. So my trademark is invest in your idea. And so what I find is that it's important to invest in your idea. Like, you actually have to take the steps to invest in it. And ironically, someone contacted me today, and it's not the first time it's happened, but because inventors don't know what to expect, some are even hesitant to tell their attorney what their invention is, believe it or not. And I had to explain to someone, look, if you're not even comfortable telling your attorney what the invention is, no one can help you. And I can understand, the concern about someone taking the invention away, but to me, the hard work is done. If you're an inventor and you've taken the time to invent something, that's the hard part. The next thing is, once you feel comfortable and you hire that attorney, the attorney's going to take care of the patent prosecution process, the trademarks, or any copyrights that you have. But what you can expect when you have a consultation is that that establishes an attorney-client relationship.
Right.
So you should feel comfortable talking to an attorney about what your invention is. You should be able to tell them, and that doesn't start the clock in terms of you disclosing your invention, because once you disclose it to a third party that's not an attorney, you only have 1 year to file a patent application, or it's considered given away to the public.
Right.
So the key is, when you have that consultation, be prepared for an attorney like myself to go through and explain all your options in terms of different types of patents to file, what information will be needed, and then most importantly, research. That's going to be my underlying theme throughout this whole interview. Research is so critical, but you have to make an investment, because, you know, when I think about this, it's a small price to pay if you do have the next billion-dollar idea. You need to be able to protect it.
Well, that's interesting. So you gave me the image before of someone coming to you and won't reveal their inventions, like being sick and going to the doctor and they take your clothes off and you won't do it. It's a little hard for them to diagnose you, you know. So hey, Jim, let's go back and forth. And by the way, if either one of you want to jump in at any time, it's great. But Jim, let's talk a little bit more about some of the independent inventors that have come to you. I know I should fully disclose that I know these guys pretty well, so I know most of the answers. But you've had some small timers or independents come to you and have gotten pretty big, right, in the medical business and others. Do you have some examples of some successes that you'd like to share with us?
Oh, sure. There's a client that came in as a pro bono client, meeting the criteria of the National Pro Bono Council. And we got a patent application for him and his company, which has to do with leveling doors when you install doors into a door jamb. Is he a billionaire? No, but is he supporting his family with the money he's making off an idea he had? He absolutely is. And that's an inventor that starts out as a pro bono client, then builds the business, and now is a regular client. So that is a real success story. And if you dig into it, it's somebody who has a practical idea that somebody needs, and it's a better way to do it.
Cool. Well, it makes me think for a second. I'm going to come back to Andrea in a second, but you know, you and I, Jim, have spent a fair amount of time in Washington, D.C.
It is true.
At meetings.
Yeah.
Great pictures in front of the White House. Thank you.
No crowds, no helicopters.
I remember something you said. I'll remember as long as I live. We were at a meeting with at the time the director of the patent office, and we were talking about, you know, the PTab process and some of the new things with patents and so forth. And you made a very simple statement that people rely on patents, you know, to get their companies started and to raise capital. And I know that you've been through that a lot of times with your practice, and the importance of having some sort of property rights to sort of raise funds, and that it's really important to be on solid ground and not have shifting ground. In other words, you raise money to get started, and then later, you know, your patent gets pulled or something. Can you just talk to that for a few minutes, and then we'll get back to copyrights with Andrea?
Sure, and I'll answer it in a little bit different way than you asked it. If you get a patent, and it's the strongest patent for a product, which is just an amazingly lightning rod product, the patent isn't what will make you rich or allow you to meet payroll or do whatever. It's the quality of the product and the advertising and the sales force and the responsiveness to your customers. All of that tied together, and the patent is a piece of that. So if the patent is looked at as something that goes together with that whole business plan, and what it gives you is exclusivity, no one else can sell it, then that is a piece that goes in with all the others that makes you a successful business. Now, the patent that gives you exclusivity and no one can design around it has yet, I think, to be issued. So what the patent will do is will give you exclusivity for a period of time, and you have to use that period of time to your best advantage. So stepping back from all that and maybe answering the questions you asked, the patent is one of many tools that you employ. It's an important one, but it doesn't do it all by itself.
Now, do you feel as if, you know, since the AIA, and I don't want to get political, I'm just looking for general, are patents just as popular today? Are you just as busy? Do you find that some of the PTab things have affected your business at all, or is it sort of business as usual? And just generally, I'm not trying to start a fight. I'm just trying to get a feel for what's going on in America right now.
Sure, and it's just the view from my own practice, right? So for my larger clients, and I think across the profession, larger corporations, they spend as much money as they have on a patent portfolio in many instances, but they're more precise in terms of which inventions they go after for patenting, and they take more time and spend more money on each of the patents. That's an observation. In terms of independent inventors and the PTab approach, et cetera, one of the things that I take into consideration when I'm representing individual inventors is that often I have perceived, it's just me, it's me, I've perceived a bias against individual inventors. And you have to try that little bit harder to convince the patent office or convince the PTab that this is something that is real, that is something that is worthy of exclusivity. And I don't know if that's true or not. You and Andrea can talk about your own experiences, but what it tells me as a lawyer is that I have to work just a little bit harder when I'm working with the independent inventor.
Interesting. Well, Andrea, I definitely, we'll have time. We want to talk about copyrights, but I'd like to kind of, if you want to weigh in on the same subject right now, what your perception is these days. Is it harder, easier for inventors, or like Jim said, do you have to take more caution?
Well, I like what Jim said. I just wanted to add that for all the inventors that are watching, there's so many benefits of intellectual property, and you can license it, you can assign it, you can sell it, you can will it. So it's extremely valuable, you know, that you protect them. And a patent, like you said, affords you that opportunity. Now, once you get the patent, there's still more work to be done with making the invention. Will you license it? What will you do with it? Now, I have worked with several clients similar to Jim, from Fortune 100 down to John in the garage tinkering with something. And I've been at the PTab with those clients as well. And I don't think that the patent office specifically singles out inventors in terms of saying you're small and you're large, and so your invention is worth something different. But I think that often what happens is that independent inventors have more simplistic inventions, and sometimes those are the best ones. You know, they're cheaper to make, they're simple, they're easy to understand, and they're solving a problem. So I think that they're still as valuable as something that IBM would want to patent, but they just may not have as much money to invest in it. But it's an uphill battle at the PTab, because you're going through the process of filing an application, then 9 times out of 10 it's rejected. How many rejections you'll get, who knows? And then the patent office has all types of protocols in place where you can call the examiner. Now with COVID, they have a lot of accelerated programs. So the key as an attorney is, it's just my job to stay updated with all the options that they have and present those to my clients to give them the best option. But to me, all inventions are worth something, especially if you created it, and sometimes you have to fight for it.
Well, I'll just add to what you said, Andrea. As an open innovation expert in running open innovation programs for large companies, the patents are still extremely valuable. You know, I've done about 120 licensing deals, and 119 of them have been based on patents. So it is a property right that is a glue that sticks things together. So no matter what everybody's heard and said, you know, you got to get a good attorney to represent your rights and educate you, but they're still very, very, very important in the process here. So we want to make that clear to everybody. So, but Andrea, let's have some fun, because, you know, we always have a limited amount of time, and switch over to copyrights, which I know you have a lot of expertise at. Copyrights is another form of intellectual property. So maybe you could describe the various forms of intellectual property. And then, of course, needless to say, you must tell the Dr. Dre story, but maybe you'd start with the facts first.
Okay, so great question. Intellectual property is divided into three parts: patents, trademarks, and copyrights. And so you want to know the difference between each one so that when you're ready to consult with an attorney, you're able to articulate what you have and the type of protection that you need. So if you have an invention, you're going to patent that invention. The name of that invention would be protected with the trademark, and then any written works will be protected with the copyright. So you may patent the television, trademark Sony, the name of that television, and then copyright any scripts or instructions of how to use the television. So that's how you really keep it straight. So the case that you're talking about is a trademark dispute with Dr. Dre, D-R-E, the producer, versus Dr. Dre, D-R-A-I, the medical doctor. And so basically the medical doctor filed his trademark application for all types of medical services, all types of products that were all related to his business. And his name is Dr. Dre, and he's America's OBGYN. That's what he's known for. And Dr. DRE, the producer, basically filed an opposition to challenge that application. And so normally what happens, as you know, is celebrities have a right to license their name. So we don't think that Oprah's really in the kitchen making soup, or Dr. Dre, the rapper, is really in the lab making Beat headphones. They license their names. And so Dr. Dre, the rapper's argument was, hey, you're trying to make a profit off of my famous Dr. Dre name. So that was one thing. He also tried to argue what we call dilution, that you're going to try to bring the value of my brand down and that customers would be confused. And so to make a long story short, I represented the medical doctor and won at the Trademark Trial and Appeal Board. And I'm very proud of that because Dr. Dre, the medical doctor, persevered. You know, he beat a billionaire.
Yeah.
And, you know, we beat a billionaire, I should say. And I'm very proud of that because it just went viral around the world. And it opened up people's eyes to say, wait a minute, why would this doctor want to trademark his name in the first place? And so it started the dialogue about trademarks, because every day when you're watching TV, there's a commercial about inventions. If you have an invention, patent it. But you rarely hear someone talk about trademarks, and they are so valuable. And so it's something to think about, that if you are using a word or a symbol or a sound or even a color as a source identifier and people perceive that as a real brand, you should be considering trademarks as well.
Well, it's really interesting because I actually have done the one that wasn't based on a utility patent, was based on a trademark of one of my licensing deals. But, you know, it usually, Andrea, it takes a little bit of time. You know, obviously Dr. Dre is a little bit different, but it takes a little bit of time for a trademark to become accepted in the marketplace. And so a lot of times inventors come to me and they'll have like a non-provisional utility patent, but they will also have trademarked a name. And they'll ask me, do you want it both as a package? And I'll say, sure, we do. But quite frankly, the name doesn't really mean anything to us in the beginning. We haven't even merchandised it. At what point do people have to trademark? Right from the get-go when they get started, or can they see how it does in the marketplace first? I'm sure you have experience on all that.
Well, I say, why wait for Oprah to say your name, you know, to get that trademark? I'd rather you file it as soon as you know, and the government even allows you the same opportunity. So you can file a trademark application as an intent to use application, saying, hey, I haven't used it yet on this widget, but I plan on it. So that's a good start. Or you can say, hey, I'm actually selling this product in and out of state. I'm doing business using this name, and I have the trademark. But, you know, often what I see in my practice is some people have great ideas that unfortunately aren't patentable inventions. You may have the next McDonald's, and imagine if Burger King would have said, oh, there's already McDonald's. So you just compete with your brand, and the brand is everything. So I always give the example, if I hold up a blue Tiffany color box and just a black small jewelry box and say, which one are you going to choose? You're going to go for that Tiffany box, even if it's the same necklace, only because you've been trained by that brand that that's going to be worth something.
Well, that's why they just sold to a French company for $17.6 billion, right? So has Oprah mentioned your name yet? Is that...
Hey, I met Oprah, but I'm still waiting on her to say my name. But when she does, you'll know. That's
pretty cool. That's pretty cool. I sent her once, by the way, I had a saucepan stirring device, and I sent it to her with a lemon curd that I made. I never thought about the fact that she's probably not going to try the lemon curd from someone she never knew before coming in through the mail, but I did get a nice note back from the producer thanking. So hey, Jim, so just, obviously we have limited time, switching back to you. Let's talk about pro bono a little bit. I don't know if people realize and recognize that Jim Patterson is the father of the United States Pro Bono Patent Program and Commission. And if you want to tell how you got started, but tell us what's going on today and a little bit about a summary of how you've grown out the program.
So you asked how we got started. I can tell you that story if you like, or jump right into where we are today. You go ahead.
Quick, the story is always fun, so you can tell.
Oh, okay. Our law firm for a period of a half a dozen years or so hosted a yearly spring seminar, and one year we had David Kaplos come, who was the director of the United States Patent and Trademark Office. So my wife sent me off to work and said, be a good boy and don't embarrass yourself in the firm in front of the director. We had I got to introduce him, which was great fun. And matter of fact, leading up to the introduction, I had a number of interviews with examiners, of course, over the months. So I reached out to each of the examiners on my case, and then I'd say, hey, how's that new director going for you? So I had all these quotes from examiners. So I introduced the director by reading all the quotes from the examiners. And they were all superlative. Well, so then we did that and we had lunch together, right? I go home and my wife says, well, how was it? I said, it was fabulous. He's a wonderful human being. I know I'll never see him again in my life, but it was, wow, it was awesome. And I think I last spoke to him now 6 weeks ago, because what we had talked about at lunch, I'm not sure how it came up, other than he's very involved and I have been very involved in pro bono, providing patent law services for free to those that can't afford them. And we talked about that all lunch. Well, out of that lunch, that's the beginning, out of that lunch came the program that is now in all 50 states and is also in 7 countries worldwide.
Yeah, and you worked with the USPTO, right, to get it off the ground. I mean, it didn't exist before a number of years ago, right?
That is correct. And actually, the Patent Pro Bono program is the first and only pro bono program that is sponsored and funded by the federal government.
And now the commission today, what are there, 7 members of the commission today? Still advises and so forth and everything, but right now I think there's a hub. I mean, every state, not every state has a hub, but every state is serviced by a hub, right?
Right. There's I think 21 or 22 regional programs that cover each of the 50 states. You can type in USPTO Pro Bono and it'll come up and you can see where you call or write or email to find the hub that would service the geographical area you are in.
And if you folks are listening, and you can go to the USPTO website to learn more. If you have any questions, you can send them to the UIA or to any of us, and we'll hook you up with the right person. We do have an executive director that takes on a lot of these leads and calls. And so to me, Jim, and then I want to talk with Andrea about Make 48, because that's another cool program. But to me, Jim, if innovation is going to be important in America and important to the country, then everybody has to have access to it. And that's why I think the pro bono program, makes a lot of sense. And I know the program's not that old, but are you seeing sort of a rise in applications and so forth? What's the on the ground feeling with it?
We are seeing a rise in applications, and I can tell you that the Dr. Iancu, the current director of the Patent Office, is very interested in the program and very interested in seeing it be successful and very interested in seeing that it grows. So it is well accepted now. Initially, Warren, you were part of the solution to the problem of individual inventors not trusting the Patent Office. And to get them to engage with the Patent Office. I'm sure that feeling is out there still, but I don't encounter it. I think the inventor community, by and large, accepts the program, accepts the patent office's involvement in it. And yeah, it's strong. It's here to stay.
And I think that's what's all critical here. And for those that are watching, between what we do at the United Inventors Association, all the independent clubs, and the pro bono program, we're all trying to share information, work on a one-on-one individual level to get you folks going in the right direction. So again, reach out to us. My email, by the way, is www.tuttle@yahoo.com. So at any time anybody wants to email me, I'll get you in touch with the right people. But so Andrea,
I was going to say, Warren, you touched on a very important point there, which, and again, just briefly, the UIA does not make money from other people's inventions. The Pro Bono Advisory Council, which is what we are called now, does not make money off of other people's inventions. UIA and the Patent Pro Bono program is there to assist and help inventors get their constitutionally guaranteed rights, patent rights.
Absolutely. And both organizations are registered 501c3s, which I'm sure people have heard the term, but what it means is we have to adhere to, federal regulations and file tax returns and have a board of directors. And we are not profiting, nor would we ever profit from this venture. But Andrea, you certainly can also add your thoughts to pro bono, because I'm sure you have a few, but then I want to ask you about Make 48. So do you want to just talk about pro bono for a minute, and what would you like?
Well, I want to add that they also have the trademark pro bono opportunities at the USPTO too. So if you all are watching and saying, hey, I'm not in a position to trademark without assistance, you can also look at that program as well. And I taught the Trademark Law Clinic at Howard University School of Law, where I supervise students in filing those trademark applications. So I know there's a list of schools around the country where the law students get that great hands-on experience, and then the clients, they're real clients and they can get their patents and trademarks. So definitely take advantage of that program if you qualify.
No, that's great. And what's great about all the UIA board members, you guys give of your time so much in so many different ways, and we really appreciate that. But let me, the clock keeps ticking. So Andrea, let's go to Make 48. I saw you out there in Kansas City. We had a fun couple of days. That's a program for people who aren't familiar with it, on public broadcasting. It's a competition. Tell us about your experience at Kansas City. And I know, again, you give of your time there to advise all the contestants, right, on IP matters.
Yes, I love Make 48, and how fitting to say the clock is ticking, because literally the clock is ticking. So basically the premise of the program is that there are teams who are given a concept or some problem to solve, and they have 48 hours to solve that problem. And in those 48 hours, they're making the invention, they're pitching the invention, and they're trying to ensure, as far as what I did as a patent attorney, is ensuring they're not infringing on existing inventions. And imagine, for all the inventors watching, it takes forever, right, to invent in the first place, but to have this huge clock, just ticking, and to be in a small room with other teams who are competing against you, and to see that one team is already making their invention, one team is already, talking to the patent attorney. It can be really a lot of pressure, but it's so exciting to see what could be done in 48 hours. And I think the lesson that I learned being the patent attorney on the show is community is key. So when you have a good idea, if you surround yourself around the right group of people that can help you make it, that can help you pitch it, that can help you advertise and protect it, you really can get things done. So definitely check it out. I'm on seasons 2, 3, and 4 of Make 48, so you can binge watch it now.
Now you've been involved, right? They had one at the Smithsonian, I think, and other locations, right? So you've been doing...
I love it. And I think that I love that the teams are comprised of family members, it can be strangers, and it just goes to show that having the right group of people around you to, push you and encourage you, and not always say yes. There's some things that occur where it's like, oh, this is tense, but it's really good. And it's sort of a documentary style. So if you're looking for something good to watch that's inspiring, I think that that's going to be something that really pushes inventors who are watching to say, look, if they could do it in 48 hours, I could do it too.
Well, it's so funny because I was working on mentoring, and more from the open innovation and company. And every time I looked up, you were working like crazy. and everybody really wanted to talk to you about patents and all that. So you played a big role in that show. So
It's
make
fun.
sure, make sure Make 48. It's on public broadcasting. It's on almost all the public broadcasting affiliates around the country. I'm sure you can go online and find back episodes. But so Carmine, we've got, I'm sure some questions have been rolling in. Do you want to jump in here? And I'm doing all of the yapping,
Questions aren't the thing. We got a lot of questions. So,
Okay. All right, I'll let you take over for a
I'll
little.
I'll read out the question, Warren. I guess then you can see who you want to answer. First off, as soon as you mentioned pro bono, everything lit up. So how can somebody apply, or how do they get into the pro bono system?
Hey, Jim, you want to take that?
Sure. Right. First, where does the word pro bono come from? It's actually short for the Latin phrase pro bono publico. And pro bono doesn't mean for free. It means for the good of the public. So who can apply? Well, for the good of the public, we want to reach out to people that otherwise couldn't afford good representation in front of the patent office. Each of the regional programs has their own criteria, but most of them center around 300% of the poverty level. So whatever the poverty level is in your state, multiply that by 3, and the programs are available to people that make no more than that amount. And the idea of setting the level there is to be able to reach out to enough people to make a difference, and not to overwhelm the system with people that could really pay for it themselves. So that was the first question: who can apply, and what are the criteria? And I think the question also again asked about how do you get a hold of the patent lawyer? How do you find it in your region? And again, if you use the phrase on a search engine, USPTO Pro Bono, it will come up for you, and it's very easy to see and read, and it will get you to where you can reach out to the pro bono facilitator in your geographical areas.
Yeah, and if you can go, the U.S. Patent Office website is uspto.gov, and then you can do a keyword search for pro bono on there and go to it.
Right.
If all of this fails and it's 3 days later and you've forgotten everything, send an email to the UIA administrator. Go on the UIA website, uiausa.org, or email me at www.tuttle@yahoo.com, and we'll get you in touch. We also have an executive director who oftentimes drops what he's doing to make sure individuals are connected with the right people on the ground. So thank you, Jim. Cool. Appreciate that.
Cool.
All right,
and,
come on. Let's
Andrea, a question came in for you. Should someone have a working prototype in hand before they engage your services?
A prototype is not required. However, you do have to have more than an idea. So you need to be able to describe the invention in a way that someone can make or use it. So as long as you can describe it, and you don't even have to have formal drawings. I mean, people come to us with sketches on napkins. So as long as you can describe what it is and you can tell me how those features work, we can research and see if you have something that's patentable.
Hey, let me jump in too, Carmine, because I think that's a good legal answer. But as far as being an open innovation director that reviews a lot of things, I find that developing a prototype, and we don't want people to spend a lot of money and go broke on it, but it's a very helpful way to figure out what's unique about your model and what claims, that Andrea might then establish for you with some research. So I'm sure she can do anything and perform anything, but I can tell you, if you really, really want to be successful at licensing, you need to strongly consider building prototypes along with IP. Just say that.
Cool. All right. And then next one is if, man, we have so many come in. Question for international patents. What's the percentage of inventors that need to get, in your opinion, I guess, it came in, to apply for international patents? I don't know if both you guys want to answer that.
Why don't we start with Andrea with that one?
Well, there's no such thing as a international quote unquote patent. So every country does have their own rules and laws. But the US does have a program called the Patent Cooperation Treaty. So you can file one patent application, pay a fee to be a part of the PCT to make it a PCT application. And then eventually you can elect the countries that you want to pursue those patents in. But the key to remember is as soon as you disclose the invention or you file an application, you only have 1 year to file in those foreign countries or you lose that right. So I think the question is a little tricky about the percent. It's not necessarily a percent that need to. What you want to do is look at where you're making the invention, where your competitors are, because your patent only covers you in the country that you get the patent in. So if you only have it in the US, someone in France can go and make your invention and sell it only in France. But if they make it in France and sell it in the US, now you can enforce your US patent. So something to consider as you're kind of strategically mapping out the countries is where you want to make it, your competition. So look at all that and map it out.
You know, Andrea, when the American Invents Act passed in 2012, went into effect 2013, one of the signature issues was first to file versus first to invent. And one of the arguments that was given was that these changes that they were making in the act would get us more in line with patent systems in other places in the world. Have you found since then that you're getting more interest in international patents, or is it just sort of, has that actually been effective, you know, that law?
Well, I think it's been effective in the sense that it is the first to file. So it's pushing people not to wait. You know, it used to be that people would file, and if the patent office cited something, you could basically prove that you invented it first. But now it's whoever gets it in first. So there's this rush to file to get the filing date. And I like that because then you're not sitting on these good ideas, you're acting on them.
Sure, sure. Hey, Jim, why don't you jump in a little bit, because I know your partner used to run the World Patent Organization. So maybe you have
Yeah, right. The Patent Cooperation Treaty that Andrea mentioned is administered by the World Intellectual Property Organization in Geneva. And Jay Ersling was the director at WIPO for 7 years before he came to work for our firm. Like Andrea, it is an interesting what percentage. That isn't what percentage of the inventions actually go international as domestic. Well, I would answer that by saying the same percentage of products that have an international market and sales base. So if you think about, oh, I want to go to France and Italy and whatever, don't think about, should I patent it there first? Think about, yes, I do have a market there, and these are the steps we're taking to make sure that we have sales agents there, or we have a way to get it out there, or whatever. The patent would follow the commercial interest in each of the companies. So when folks come to me and they say, should I file in the US and Canada? Well, we're in Minnesota. Often there's a market in Canada for things made in Minnesota. But then we sit down and we go through, do you envision yourself doing the steps necessary to get to Europe, this or that? And if the answer is concrete and yes, I'd say, okay, let's take on the patent expense and see if that makes sense now. So
yeah, because it's not inexpensive. But one of the cool things when I first met Jay Ersling, Jim's partner, and he was running WIPO, I don't know if you remember this, but he'd just gotten back from spending 4 weeks in Mongolia restructuring their patent system. And I thought, how cool is that?
Yeah.
But all right, Carmine, next. We can get a couple more in.
Yeah, we got a couple minutes left. So real quick, either Andrea and or Jim, what do you guys see a percentage, and it kind of a question, and I'm just trying to paraphrase it, of ideas or products that actually get stolen during the patent process? Do you guys see that often?
Why don't we start with Andrea?
Oh boy. So that's an interesting question, because so many people think incorrectly that their invention has been stolen. And what I mean by that is your invention is only protected by a strong patent, right? So it's not a percent that someone can change the invention. It's not that it solves the same problem. It's taking a look at the claims in your actual patent and determining how to interpret those. And you know, at the patent office, there used to be this saying that patents can be used as swords, you know, to kind of fight people off. And so that's the way you think about it. But often when I hear that question, it's from people that may have a consultation and say, okay, help me because I disclosed my invention to an invention company and now I think they stole it. Well, just because you had that idea or you thought about it or you saw your product on the TV stores, shelves or on TV doesn't mean someone actually stole it. You have to look at those patents that you have for patent infringement. Now, maybe you did actually go to a company and you disclosed it and you have a non-disclosure agreement and maybe they took it and did something with it, but then the infringement is only as strong as the non-disclosure and being able to enforce it. So the best thing is nobody can necessarily steal your idea if you have it patented. So instead of sitting and kind of waiting and asking those types of questions, take the steps to protect your invention and get a strong patent and seek the help of a good patent attorney to help you map all that out.
You know, the NDAs, the non-disclosure agreement, is a really good point. And I think it's a great litmus test if you're eventually going to take a product to a larger company to license it. It's a great window into the company to see how they wrote that NDA. And I would recommend to you, if it's a complicated NDA, to take it to someone like Andrea, have her take a look at it and interpret it for you. But you want to see if it's benign or friendly or if it's adverse. I've seen many adverse ones. And if you have an adverse NDA that's all in the company's favor, you got to be very, very careful, right, Andrea? I mean,
right. And, it's a good point because some companies don't even sign NDAs. Like someone like you, Warren, that sees so many inventions will say, look, I'm not going to sign anything. So that's when having those patents are really valuable, because now if you go and I disclose my invention to you, it's protected with the patent, so I can enforce my patent if I need to against you.
No question about it. And just to add color to that, on my end, I do NDA. I just did one this morning. I sign a lot of NDAs, but basically I don't sign an NDA blind. A lot of inventors will say, I have an idea, sign an NDA and chip it in. Trust me, I'm not sitting here waiting to see your product, okay? I've got plenty to do right now. What I have is a questionnaire that doesn't ask for anything specific. It just asks you where you are in the development process and generally telling me. So I can even see if it's a fit. I'd say half the things I get requests for aren't even products that I'm have any interest in or expertise in. So, but once I have an idea, then we'll sign a non-disclosure agreement, in time. So sometimes you take those things in steps, and also recognize that companies oftentimes have their own NDAs. They prefer you sign that. Why? Because they might have to sign 300 or 400 NDAs a year, and they're really not interested in sending everyone through legal. So that's why they do it. So Jim, do you want to add to that at all, or?
I was thinking in my career, there have been 2 instances where a patent application and a disclosure under a patent application were copied by folks, and we had to sue them in one. And they were offshore manufacturers, both of them, and they took the drawings and filed applications in their own, in their own country and in the United States. And so twice in a career that we won't say how long it is, but it's been a while.
Can't count the Navy.
Yeah, they're a lot of fun to tell the stories, but if I had relied on only those 2 to feed my kids and put them through college, they wouldn't have made it.
Right.
So.
Right. Well, that's a really good explanation. So Carmen, I only have time for one more question because unfortunately I have a hard stop at 3 with an important conference call. But why don't we ask one more and then we'll thank our guests. But
okay, yeah, and what I'll do for any of the listeners is that I will send the questions we don't get to out to Andrea and Jim, and we'll try to get those answers back to you. So the other question is the question really that you guys probably hear a lot. A quick explanation of the PTab board, because we hear it a lot and no one really understands what it is or what they do.
All right, who wants to take that one?
Well, Andrea, you've argued there, and I've watched my partner argue there, so I think you should go first.
Well, okay, so what happens is when you file a patent application, 90% are rejected, and you get a non-final office action. Sometimes you can respond, convince the patent office, then you get your patent, you're good to go. Now, sometimes you respond, they may not agree, they issue what's called a final rejection. Now, after that final rejection, you have the option to file a request for continued examination to keep the non-final, final, non-final, final. You can keep that going, or you can say, look, this examiner doesn't understand what I'm doing at all. I'm going to just go beyond the examiner and file at the PTab. And basically, yes, Patent Trial and Appeal Board. And basically that's a panel of judges that's assigned to the case. So at that point, you write your brief and you put all your arguments in with facts based off of what you already submitted, though. So you aren't allowed to add any new arguments. The examiner at that point will respond with their brief, and then you wait until it gets before the judges at the PTab. At that point, you can request an oral hearing where your attorney will go and present arguments on your behalf, and it's just you and typically the panel of judges, and they ask you direct questions in a limited amount of time. Or you can not request the oral argument, and basically they read your brief, what's on in writing, and rule whether or not the examiner made a mistake, and then they send it back to the examiner to say, hey, you made a mistake, they should get their patent, or they will agree with the examiner and say, sorry, you're not going to get a patent. At that point, though, if they do issue a final, they agree with the examiner, you can then file an RCE again, a request for continued examination, maybe put some new arguments in and go back to the examiner. You can just keep going. It can be a hamster on a hamster wheel, but hopefully one of those will work and you'll get your patent. But that's it in a nutshell.
Yeah, and there's also, you can also be issued a patent, and if someone infringes and you go after them, they can actually, instead of going to court with you, bring you back to a PTab review. So, and we had a really dynamic session with the PTab arm of the Patent Office last August with the club leaders. And we're going to have another one. We had one scheduled when the outbreak of the virus took place. So we'll schedule another one, if not August, maybe September, and get people back involved in that. But Jim, you want to add to that, all that too, a little bit?
Sure. Yeah, we could talk for hours on the procedure of the PTab, and it would become very arcane very quickly. So how do you think about it simply? Well, the Patent Office is a government agency, and you deal with the government agency. And if you say, you're not doing this right, who do I talk to? I want to talk to the manager, right? Well, you can go to the court system and say, the Patent Office isn't giving me a patent and they should. Or you can go to the court system and say, hey, they gave my competitor a patent and there is no way that they should have given them, my competitor, that patent. So you take it completely out of the Patent Office. Well, it's driven, the PTab is driven by finances. The cost to challenge that patent or to complain about the fact that you should have a patent and the Patent Office won't budge in federal court becomes extremely expensive. The idea of the PTab was there must be a procedure that we could put together that for less cost, these decisions can be made. So you can say, if I'm not happy with the Patent Office or with what the Patent Office did, I can go to the federal court system, or I can go to the PTab. PTab gets you a decision faster and for less money than in the court system. Whether that,
Jim, let me jump in because we're going to have to wind up. We're going to do,
sure.
And thank you. That was great explanation from both of you guys. But there's been some additional unintended side effects of it, and so we're going to tackle this subject all by itself, and we'll keep you guys informed on that, and we'll get these two guys back on with it. So we thank you. So Carmen, I'll let you wrap it up because I have a hard deadline.
Yeah. No problem, man. No problem. Warren, thank you so much, buddy. I know that you got to get going. All right. Well, that was awesome. We had some great questions. We have a bunch more questions. As you guys know, Andrea and Jim, whenever we talk about intellectual property, we get a lot of questions, and I know you guys do. But I'm so glad that you guys reinforced that intellectual property is very, very important in almost every business, not just inventors. Your business should be built on intellectual property. That's my opinion. And having these two great guests on is really something that you don't get to see too often. So I thank Andrea Evans and Jim Patterson for being on today. Again, reach out. I want to jump on real quick back to Jim and Andrea for them to give their contact information, and then we'll close up the show. So Andrea, can you go first?
Yes, thank you again for the opportunity to be here. I'd like to encourage you all to text Evans IP Law to 33777. That will allow you to subscribe to my firm's newsletter. You can find me at Evans IP Law all over social media, and you can follow my website for more updates about things and subscribe on the firm's website at evansiplaw.com. Thank you so much.
Thank you, Andrea. Go ahead, Jim.
Sure. The website is ptslaw.com. Tango Sierra Law, ptslaw.com. And my email, patterson @ptslaw.com. Enjoy.
Very good.
Thanks so much.
Very good. Thank you so much. And thank you everyone for listening in today. Again, any questions, send them on in. And for Jim Patterson, Andrea Evans, Mr. Warren Tuttle, myself, Carmen Disco, thank you for listening. And we will catch you next week live on Thursday for workshop number 8. Go ahead and you all take care.
Thanks,